Okay. Hi, I'm Dahlia Lithwick. I cover the Supreme Court for Slate.com, and I think I've been doing it for 15 years. Kagan had a great run where Elena Kagan at her hearing said, yeah, I would be really open to this. You know, here's a kid who grew up on TV, right? She's not like, I was listening to the fireside chat on the radio and this weird TV thing got reeled in, right? She's not that. She grew up like the rest of us, Gilligan's Island. And so she was fine with it at her hearings. And then she went to Colorado and I think gave this really nice speech almost immediately after her confirmation saying, you know, one thing I learned being SG is that it's really important for people to, you know, see oral argument and to understand how awesome and intricate and lofty and, you know, vaunted the work is. And it's great. And we shouldn't have cameras, you know? And so I think it's like they turn on a dime. And I think for a long time that was just respect for, right? Because the suitors of the court who were like, you're rolling those cameras in over my cold dead body. And that was, I think, deference to Souter. And a lot of us thought, wrongly, that when Souter left, they would reconsider because a lot of them were saying, you know, we're doing it out of deference to our colleagues who feel very strongly about it. I think that I'm pretty cynical about this. I think that the big underlying reason for this is just privacy. And they feel like they don't want to be recognized at the Safeway. They don't want to be, you know, yelled at as they're jogging. And I think they're terrified of Jon Stewart, you know, taking a minute and making them look stupid. And, you know, I have long said that we could do that with audio and should take a minute and make them look stupid because audio, you know, and puppets, you could, if you really wanted to send up the court, you could use the audio to great effect. But I think that the real answer is that this is not really about, you know, some of the pretextual arguments that are offered against cameras, you know, that it's too complicated and Americans couldn't understand, and, you know, look at what it did to you know, the Congress, and it's corrupted everything and people are going to grandstand. You know, my answer, and it's the answer to all questions in life, is just Canada. You know, like Canada has been taping their Supreme Court for decades without incident. And, you know, you know, the argument that not only are we so special that we're different from all other branches of government, but we're so special that we're different from other Supreme Courts of other nations like Canada and the UK, just strikes me as crazy. It's just crazy. And so, you know, I get it that insofar as part of it, and, you know, Justice Thomas and Justice Kennedy really worry about security. I think that's, you know, when they testify about it, what they're afraid of is being recognized. And, you know, a little bit of me wants to say, you know, this is the wrong job if you don't want to be recognized, because you're one of the most consequential political figures in the country. And I don't know that that's enough. I mean, what you would be gained is simply watching your government do its job. I mean, I think even if the government's job is hard or complicated or inscrutable, the idea that you don't get to watch them do it is nuts. So I think what you're gained is simply the value of, in a democracy, you get to watch people do their work, period, end of story. No, I mean, in my view, most of the benefits of the television I think you could get from audio. So if there were a meaningful same-day audio, I would probably be mollified. I'm not sure. I mean, I think we live in a world where people consume things visually. And so I think the difference is it would just be more interesting to people. And I don't think that's inconsequential. People would watch in a way that they might not listen. But I think most of the benefits of transparency could be gained by audio. But I don't think that people sit down or want to sit down and read a transcript. And I also think that what is missing from the transcript is what's interesting. So for me, and this is, I just think as one of those people who's been in that chamber watching oral argument, sometimes I read a transcript afterwards and I think, wow, I was not at that argument. Because what I'm seeing, and body language and people cutting each other off and three people trying to talk at once, none of that appears. And so a lot of the interesting, and I don't pretend to be nearly a deft enough court watcher to be able to say, like, oh, I saw the moment in that argument where Kagan got Kennedy on side. You know, like, I can't say that. But that's interesting, and that's a part of this. And the idea that oral argument is for the justices is belied by the fact that it's happening in an open chamber with spectators. So I think once you concede that the public has a right to be there, then you're having a fight about whether it can be the 60 people who stood in line or all the millions of people who really want to see. So in other words, I guess what I'm saying is, if you're going to take the posture that there's no place for the public at oral argument, then don't have it in an open chamber with people lining up outside. Because as soon as you've done that, I think you've conceded the point, which is this isn't just for the justices. This isn't just for them and the lawyers. This is the public getting to see how the court is going to arrive at what they do. And once you say there's a value to that, it seems to me just completely capricious and arbitrary to say, you know what, if we put in 3 more rows of seats, we could let more people in. Once you're doing that, I really do think, and you know, it frankly, I just think anybody who isn't infuriated by the fact that before the ACA cases, people were lined up on the sidewalk, we're paying people to line up on the sidewalks in the rain for 3 days, like, that's not how government works. That's wrong. People should be mad about that. Yeah, I mean, I think that's a really good reason to not do anything stupid at oral argument. I mean, you know, it's sort of like, why are they different from any other public figure who is a target of Jon Stewart's merciless mockery? I mean, I just think, you know, part of being a big boy or a big girl is saying, yeah, this is a little bit of the cost of being in a democracy. People are going to poke fun at you. But, you know, I think the idea that we're too awesome to be mocked on The Daily Show doesn't, for me, hold a lot of political weight. I mean, if you want to have gravitas and be taken seriously, have gravitas and be taken seriously. If you say goofy things at oral argument, sorry, you and the rest of us are fair game, and we all say goofy things. And I think one of the paradoxes of this is that the justices get so mad when they're quoted, when they're, right, they're constantly saying, oh, you pulled that one broccoli line out of the, you know, or the Cornhuskers kickback out of the ACA arguments. You said it. You know, I think if you say it, you can't then be angry at the press for reporting it. So I think there's almost like a feedback loop where the justices feel that they are so immune from scrutiny that when they're scrutinized, they're like, but wait, we're immune from scrutiny. And it's like, you've allowed us kind of this much of a portal into the court. You can't then get angry at print reporters for doing what their job is, which is to relay what you've said and done. And I think there's this notion that, like, they're so cocooned off from the world that they're in fact invisible, you know, and that is just wrong. It's just palpably wrong. And so this idea that, you know, it always has seemed to me that, you know, the huge fix to not liking the press interpreting you in ways that you think are unfair is to have cameras in there, because then nobody's interpreting it, right? Then it's just the world is watching. And so you can't both be angry at the messenger and say we're not going to allow direct access, because then you're just like seeking invisibility and seeking zero accountability. And that's not, it seems to me, the trend in which this needs to go. I've been wrong about this. I've been wrong about so many things. I remember thinking John Roberts, because he was the sort of first TV generation justice and had little kids who watched TV, that he would be open to it, that he wasn't going to think it was like new technology. It was just what we use. So I think that it's not as likely as I once thought that they'll be increasingly open. I think this is a rearguard action, right? I think that, okay, we'll release the transcripts. It's like pulling teeth, you know. All right, we're going to let you guys take pens in there. Don't abuse it. You know, like, I think what you're seeing is, you know, the presumption is it's 1804. And, you know, any little thing that we get other than, you know, than television certainly, but like that any little thing we get is hard fought, you know, and that's why audio was so funny to me, because it was like, this seems like such a gimme. It solves everyone's problems, same day audio, but like, no. And so I think that you know, the court is not and this goes to a much deeper problem. I think the court is not in the posture of, we want to help people understand what we do. And oh God, I'm going to say Canada for the third time in this interview. I'm sorry, edit these out. But the Canadian Supreme Court literally has this system, I'm so sorry, has this system whereby, there's an officer whose job is to explain things and to help journalists understand. I mean, who literally liaises about the justices, the cases. They have this amazing lockup system where they give opinions to the journalists, take away their BlackBerries, let them actually read the opinion for the 2 hours before the decision is announced so that reporters don't make mistakes. So there's just a systemic effort, and a lot of state courts do this too, to help journalists get it right. And the U.S. Supreme Court, for all kinds of complicated reasons, doesn't see that as part of the problem. And so there tends to be, I think, the public posture is when the press gets it wrong, that's on them, right? When they misreport the ACA decision, when they get Bush v. Gore wrong, that's just on them. They should be able to do their jobs. And I think because there's that sense on the court's part that they have no obligation to make it slightly easier for the press not to, really fundamentally cock things up on big decision days. What happens is just this general feeling that the press, do your best with what we give you, and thank God for SCOTUSblog for, thinking of original ways to do that, but you're kind of on your own here. And if, it's a multiple 100-page opinion and you just can't read it or you get it wrong, you look stupid, not us. And I think it's this question, and Tom Goldstein wrote about this after the ACA, whether there is a cost to the public or the court when the press gets it really, really wrong on things. And I think that the court's feeling is there is no cost to the prestige of the court when, CNN or Fox or whoever makes a huge mistake on a decision day, they look stupid. And so I think part of what I'm struggling with is, the court, I think until the court has some ownership of how the story comes out, the court absolves itself of how the story comes out. And then it's really just, a sad story about the press trying always to get slightly better systems to do their jobs right. And I think that what's interesting to me isn't the TV, not TV problem. It's we have no responsibility for making ourselves clearer or more immediate or more real to the world. I think that's the interesting part of the problem. And for me, it's that same blindness that I was describing earlier where, if we just pretend we're not here, maybe nobody will notice or care. And I think the opposite happens. I think people feel locked out. Right. Well, and that's always been, I think, the take at the court is that, nothing to see, nothing interesting, just trust us. This is boring and way too complicated. And I'm not sure that the American people feel that way. And I certainly think, to the great credit of the American people, when government tells them, trust us, nothing's happening here, that's when the red flags go up. The press has tried. I mean, I think there have been so many efforts to increase transparency about all sorts of things, and the press has tried. And I don't think, I think you're just in a situation where what is the press's bargaining power here? We're just going to write mean things about you. I mean, I think there's just nothing to say other than thank you, can we have some more? And I do think it's just, at the most sort of theoretical level, it's interesting to me that the court doesn't see any of this as problematic or fraught. And, when decisions come down and everybody's scrambling and you see that poor 22-year-old intern running across the plaza, this is how our democracy works. The idea that isn't, slightly headache-inducing for the justices who really, I think, all concede that their power and prestige comes from people getting what they do and understanding that they're doing something right. I don't get it. Yeah, I mean, I think there will come a day, and I don't think it's going to come soon, and I don't think it's going to be an act of Congress, when some justice, probably my grandson, who will not be from Canada, when he will say, you know what, cameras are okay. And on that day, when cameras have been obsolete for 172 years, like, you know, I just think this is part of that rearguard action. I mean, I think the day that there is no longer television will be the day that the court rolls television cameras in there and says, like, here's your transparency, America.